Hello friends, in the series on the income tax cases, today we will discuss a very important case. The name of the case is Commissioner of Income Tax versus BRANDIX Mauritius Holdings Limited. This case has been reported in 456 ITR at page number 34 and the matter has been decided by Delhi High Court and the date of the judgment is 20th March 2023. This case is regarding non-mentioning of DIN number by the assessing authorities in the assessment order, due to which Delhi High Court has kept the order passed by the assessing authorities as non-est and treated it as it has not been ever issued by the department or ever passed by the department. In 2019, the Income Tax Department came out with a circular dated 14th August 2019, in which it was mentioned that if any communication is issued by the Income Tax Department, whether it is in the form of a summons, notice or any assessment order, then to keep the audit trail of the documents, to keep the audit trail of these documents, there has been put an requirement on the assessing authorities to mention DIN number on that communication. The Central Board of Direct Taxes have realized the importance of this audit trail, because sometimes it happens that, for example, for passing an assessment order, approval of a higher authority is required. Approving authority is not available. The assessing officer passed the order. When the approving authority came, just for completing the formality, the assessing authority took the approval from the approving authority. But now this is not possible, because first of all, the computerized DIN number will be generated by the approving authority, and then the assessing officer will again generate the DIN for passing the assessment order. This is now the system. The soul of the circular is that in any summons, in any notice, any order passed by the Income Tax Department after this circular dated 14th August 2019, if any order will be passed without document identification number, then that order will be null and void if it is not mentioned in the body of the order that the DIN number has not been generated due to some technical glitches or for any other reason, and that DIN number will be generated within 15 days as per the circular. But if the DIN is not generated, it should be specifically mentioned in the body of the order that why the DIN number has not been generated. In the present case, the assessment order was passed without DIN. After that, DIN number was intimated to the company, to the assessee, and the department was taking the plea that there is section 292B which says that if any clerical error is there, due to which that notice, summons or order should not be treated as invalid. But the court said that the circular is very clear, the intention of the government is very clear, because even our Prime Minister said in a statement that if you receive any order, any notice from the department, and if it is not containing DIN, you can throw that document, that assessment order, into the dustbin. Meaning hereby that just intimating the assessee through an intimation letter or through any communication, the DIN number will not suffice the purpose if it is not mentioned in the body of the order that the DIN has not been generated because of one or the other reason. So friends, this case is very important, because when this circular was issued, that is 14th August 2019, just after the date of the circular, there was a lot of mistake on the part of the assessing officers for not generating the DIN, and even in the COVID time it has not been generated. So we can take the plea of that non-generation of the DIN by the department in our assessment orders. Friends, this is a very important case because this mistake has been done by the department in a number of the cases, and even now the department is doing this mistake. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus BRANDIX Mauritius Holdings Limited, and this case has been decided on 20th March 2023, and this case has been reported in 456 ITR at page number 34, and the matter has been decided by Delhi High Court. Thank you, friends.